get started. So that was just to give you an idea of what an alarm is. What we're seeing more and more in hospital situations is that alarms are being muted. They're being silenced, and people aren't paying attention to what the alarms are. So we're going to present to you today regarding lighting up the alarms. Both myself and Jonathan Lomurro from Lomurro Law will be presenting this topic. So the objectives today is to provide an understanding of the changing alarm systems in healthcare and how to effectively utilize them to determine the facts behind when an incident occurs. We also want to find out whether the alarm sounded or whether it was silenced and ignored. You know, when that alarm was going off, most of your alarm systems have a button, and you know, for healthcare providers, we hear alarms all the time. We have bed alarms, we have doorbells, we have the cardiac monitoring alarms. So you can hit silence, and depending on how the alarm's set up, it may be silenced for 5 minutes. So 5 minutes could go from patient being stable to patient being dead in no time. So it's a very big issue that we're looking at. The Joint Commission has also seen it, and we'll talk about that a little bit more. We'll understand the various roles in the healthcare system and how one role may not establish the standard of care for another profession. And then finally, we'll break down medical malpractice to determine the facts to get the results. So, iatrogenic injuries. Just a brief overview of iatrogenic injuries. These are injuries that arise as a result of the process of medical care and are potentially preventable by improvements to patient care. So patient comes in, they trip, they fall, patient comes in, some sort of injury occurs to them in the healthcare system. The true number of premature deaths associated with preventable harm to patients was estimated more than 400,000 per year, and this was cited in 2013. And this number is staying consistent. Even though we have our current changes for patient safety, we're not seeing a massive change in this. So hospital incidents. When an incident occurs, an incident is anything that could potentially lead to litigation down the road. Hospital incidents are events that are unexpected, that occur, may or may not be a deviation from the standard of care. And that's where you want to look at what the standard of care is. Are they falling within, or are they falling outside the standard? Incidents may or may not cause harm to patients. Those who do not cause any harm to patients are considered near misses, but institutions need to look at their near misses to know what is going on, what their processes are, how can they improve patient safety. Major events, sentinel events, are reportable events. Depending on the state, they're reported right to the state. The state comes in and does an investigation. We see wrong site operations, patient fall, especially patient falls, they're put on anticoagulants, they hit their head, they suffer a brainstem bleed. Surgery completed without proper consent, we see that a lot. Or they have consent after they've been given some sort of sedative agent which deems them incompetent to give consent. So in 2013, the Joint Commission launched the huge medication alarm safety. They're really putting a focus on making sure that we're breaking down the alarms and getting the high alarms, the alarms that are most critical to patients, either a vent being disconnected, they're in a lethal rhythm on their cardiac monitoring. Those are the things that we need to be identifying, because the problem is when you go, how many have gone into the hospital and you hear the bed alarm going off, you hear the chair alarm going off, you hear the cardiac monitoring. For healthcare providers, once they're in that environment consistently, it becomes white noise to them. So patients are falling through the cracks, and that's where we're having issues. So we look at about 98 alarm-related events reported. 80 of those 98 were resulted in death. So the Joint Commission has stated that in 2015, 2016, when they are surveying these hospitals, they're going to be looking for changes in the alarm systems. They're looking for improvements in alarm systems. So as you're getting medical malpractice or you're trying to defend a case, it's important to look at the policy and procedures of the institution and making sure that they're compliant with the Joint Commission. And these policies need to be current. They need to be implemented throughout the whole house. So it's very, very important that you look at that to break down what happened with the situation.
So obviously policies and procedures are vitally important for Rutgers. The football team follows them, coaches follow them, and since that is vitally important, now that Rutgers and UMDMJ decided to practice medicine for us. So why is this vitally important? as med mal attorneys? Well, they're public employees. So the first alarm that comes up, and it's the biggest mistake that happens with all the referrals that come to our office and a lot of the clients, they don't know about filing a tort claims notice within 90 days. So when you have something happen, and the tort claims notice must be filed, do it anyway. There's no harm in filing it. So if you're not sure, err on the side of filing. Doesn't mean you have to file a case later or that there's a claim that goes forward. But if you don't do it, you lose it, and you don't want the malpractice case to come after you as opposed to after the doctor. Now, when you're talking about those 90 days, they're from 90 days from the accrual of the incident. Okay? It's the same as a tolling provision in regards to when you should have known that the incident happened. And that usually is once there's a damage that's cognizable, it's outside the scope of what the practice area was, whatever that performed procedure was. But when you get there, it's tough, because you miss it, you're out. Now I say you miss it, you're out, but there is a 1-year exception. This is where we save. If you get that case referred to you, the client comes in, and they're like, what do you mean it's tort claims? You can make an application to the court and save that case. But it has to be made to the court, so it has to be made by motion. It's only granted in the discretion of the court. So if you don't make it and you miss this, then you're really in trouble. And there's enough cases out there that'll put those alarms really up there that say the case switches from med mal to attorney mal. So you have to make sure you're aware of it. Now, it's gotten even harder, but there's a case out there, Egan, awesome. It allows you to toll if you don't know the person is a public employee. So they're not at UMDMJ, they're over at some affiliated hospital, which is a private entity, but it's a public employee. How would you know? The case law says they got to wear a tag that says, well, I'm not an employee here, I'm somewhere else. But I mean, come on, how many times is the patient going to look up and see the doctor and be like, hey doc, do you work here? It's not going to happen. So this opportunity gives, if you could demonstrate that there's no way that patient knew, then you could toll that notification and make it later. So it follows this realm. If you want the tort claims notice available to them, the state's like, well, then you got to tell them. You got to make the status as a public employee clear on the consent form, on the tag, advising the patient. Now, some of the places are doing this, some are not. But if you miss it, you're out. Here's the thing to remember. Public employees at a private hospital are still public employees. And that goes across the board for the whole state. You'd be shocked at how many teachers, and they just happen to be at this affiliated hospital. So if you miss it, you're out. So always err on the side of caution and be aware of that alarm. There's another alarm. Now I think this is unconstitutional, no one's challenged it yet. But in a med mal case that happens at birth, it has to be brought before the child is 13. So that move to 18 does not exist statutorily. It hasn't been challenged yet, but it's just one of those things that comes in. If it walks in your office, you're like, I got a long time because the kid's a baby. Not true. So this particular statute does exist, and just be aware of it. So those are two of the main pre-things. When they walk in the door, what do you need to be looking for? Tort claims notice, statute, always vital.
So when you're looking at hospital systems, we deal with a lot of different alarms in the hospitals. There's cardiac monitors, which you saw. There's many different types of alarms for cardiac monitoring. Maybe the pulse oximetry fell off the patient's finger, so it's not reading. That should be a different alarm than maybe a patient who's in a lethal rhythm where they're going to die. We have, like I said, pulse oximeters, and they can be a separate alarm. Especially, pediatrics. When you're getting into croup, RSV season, those kids need continuous pulse oximetry. And if the hospital doesn't have a central system, then who's listening for that monitor? Because if you're all the way down at the end of the hall and then your patient's on the other end of the hall, how do you know that alarm is going off? Especially if the parents are in there and they have the door closed. So it's one of those safety measures, and that's when we're looking at having beepers and so forth in healthcare systems, so that if that alarm goes off, the nurse gets a page so that they can respond to that change. So we have bed alarms. We have more and more patient falls. Is the bed alarm in place? Was the bed alarm policy followed? Many times when we see patient falls, we look at whether the bed alarm was in place or not. If it's not in place, was it broken? Did we sequester that alarm to look at have it looked at by maintenance to determine whether it was functioning or not? Call bells. You know, call bells are very loud. Patients are putting them off. Depending on your hospital system, they may have a direct call to a vocera, which is a little telephone that nurses wear around their neck so that they can respond in a timely manner. Pages, phones, doorbells, especially on locked units. You know, you may have someone looking at the doorbell trying to get people in. You have the cardiac monitors there. You want to know who's in charge of all of the different alarms. But as a healthcare professional, it can be very overwhelming, and then eventually it just becomes white noise.
Only on Eyewitness News tonight, we expose a critical concern for hospitals. It's called alarm fatigue. Doctors and nurses so overwhelmed with beeps and warnings from medical machines that the alarms go unnoticed and even ignored.
Reports show alarm fatigue has already claimed the lives of at least 11 patients in Massachusetts. So what's being done right here to prevent it? And how can you protect yourself?
So alarm fatigue, as you can see, it's in the press, it's in the news. We know what's going on. And you know, unless you have an advocate there who knows the healthcare system, you know, families don't know what these alarms are. I work in an emergency room and I see it on a daily basis when I'm there. Families may hit the silence button because they're sick of hearing the pump, but do they understand the rationale of hitting that silence button? They should not touch the pumps, and that should be an educational material. And maybe if that's the case, then you have the lock mechanism so that the keypad is locked so that the family can't silence that alarm, so it continues to go off. Because think about what we put on these pumps. We have cardiac drips that are life-saving drips. If you pause that alarm or you and it's empty, that patient may not be getting that medication, and it may be a life-sustaining medication that could kill the patient. I've seen that. I've seen it where they've turned the pump off and opened it up and drained the whole drip into the patient, killing their family member. So there's a lot of different things that you can see, and it's very, very important that we educate that the alarms are in place for safety. But the thing is, we have to also make sure that, you know, the healthcare providers are not thinking of it as white noise, that they understand they're responding, and that our hospital systems are developing safe procedures so that it's not white noise, that it's being taken seriously. So in 2014, National Patient Safety Goal number 6 was focused on critical alarm safety. Implementation is going to be rolled out in 2 phases, and we're going to start seeing this in the surveys. So starting in phase 1, beginning in January 2014, this actually got pushed back to 15, so we should be seeing it in the surveys that are being conducted this year. Hospitals are required to establish alarms as an organization priority and identify the most important alarms to manage based on their our own internal situations. You know, a lot of our hospitals, to keep up with the healthcare systems, it's very financially challenging. You get the GE systems, when you have to get the upgrades, those upgrades are not cheap. We all know it. You all have law firms. Think about your firms. When you have to upgrade your software, your hardware, it's a big cost. You have to make sure you're protected, that you have the security measures in place. Well, the alarms are the same thing, and when you have wireless alarms, it's a lot more complex. So in 2016, we're going to start seeing phase 2 roll out, which hospitals will be expected to develop and implement specific components of policies and procedures. Education in the organization about system management will also be required in 2016. So what does that mean? That means that they don't just develop those policies and procedures, that they're rolling them out, that they're educating them. So if you're looking at maybe a medical malpractice case, look at the employee's files regarding those who were caring for that patient. Are those files complete? Do they have documented education regarding the alarm systems? We see with traveler nurses, agency nurses, employees who are temporary employees, they have massive gaps in their files, and you have to be very, very careful of them, especially if you're defending a case. That's why having a clear, concise orientation plan is essential. And that's where, if you're going on a plaintiff's side, that's where you really can find your meat and potatoes for your case, because if the nurse isn't properly trained and oriented, then are they set up for failure? That's what we look at. So what happens when these events occur? Patients should record as much as possible, especially if the healthcare provider is coming out and saying, you know what, we missed something. The patient, I had a case recently, the patient developed EKG changes, which is their cardiac rhythm, the night before. Then the doctors noted it, but they did nothing about it. The next day, they transferred the patient to the floor. Now, those EKG changes actually indicated in the standard of care that the patient go to the cath lab emergently. The hospital neglected to do that, sent the patient to the floor, and it got even worse because they disconnected the patient from the monitor, did not give a report to the floor, put the patient in the hallway bed, and the patient arrested in the hallway. So these are big, big situations. So if you're getting information disclosed to you, you have to also think that everybody has a smartphone today. Look in your pocket. I'm sure you all have smartphones, and you're really well wired with your law firms. Same with patients. Patients are taking videos. They have their audio recorders on. You would be surprised at how much information that they're picking up on. They'll take snapshots of quick areas in the emergency room or throughout the house that causes them concerns and safety. Now, as a hospital administrator, I try to stop these by citing HIPAA, but you don't always know what people are doing. You can't keep an eye on everybody 24/7, so it becomes a challenge. Hospitals have their own incident reporting system. The challenge with these reporting systems is it goes under quality improvement, so unless something is cited in the chart, but even still defense firms will fight to keep that out of court. It's one of those challenging areas, but if there's something well documented in the medical record that there is a whole incident report and it was filed appropriately, it may be something that you may be able to obtain, but it's very challenging. So, information that is essential to obtain when a client brings forth an incident. Of course, you're going to need a complete set of medical records. You need to know A to Z what happened from the moment the patient arrived in the hospital to the moment that they left, whether they were discharged or whether they were discharged to the morgue. There's two ways to leave the hospital. You either walk out or you go through the morgue. So you also want to know an audit log of who accessed, documented, and potentially changed the electronic health record. You want to know why people are going into that record. And hospitals have this tracking system. They have to have the systems in place so we know who is accessing that medical record. If there's paper documentation, evaluate it for potential tampering. But at this point in time, we're getting almost no paper documentation. Almost everything's now on electronic medical record. Ensure that the equipment involved in the incident are sequestered for interrogation, especially your cardiac monitoring. You'll know when that mute for 5 minutes was placed. You're going to know when the incident occurred. You'll be able to look at before and after what happened. Make sure that there's a full investigation onto the equipment. Obtaining a complete report logs from central monitors regarding the alarms and what actions were or were not taken. You should also look at the maintenance of these alarms and the maintenance of this equipment. Is it up to date? Is it current? So, documents that you may not know about. Assignment sheets. Every unit has to have an assignment sheet. Otherwise, how do you know who's doing what? So assignment sheets document who's in charge of cardiac monitors. So if there's the charge nurse in charge, well, is the charge nurse in front of that monitor at all times? That becomes a challenge. You'll go to an emergency room. Do you see someone in front of the cardiac monitor at all times? Most likely not, and it becomes a challenge. So hospital staff records, you'll want to compare the staff that's on duty with the standard of the amount of staff that is required to provide the appropriate care to patients. So is there the appropriate staff present to be able to provide the care that's needed for those patients? Look at employee files and education, as I said before, and whether they have any gaps in the training or certifications. You'd be surprised. What if their ACLS lapsed? If it's part of the job description, then they can't work. They have to meet the essential functions of the position. Nursing supervisor reports, these are very challenging to get, but with joint commission and handoff procedures, the nursing supervisors should have a reporting process of how they're handing off report to one another. So it provides a communication tool of events that occurred, and sometimes that has more information than you may find from the medical record. It's very challenging to get, but sometimes you can get it. Personal documents. As nurses, when we're in nursing school, they always tell us keep your own little journal of all the events that you have so that you know what's going on. The problem is that's an issue with HIPAA, and if you pull a nurse into a courtroom and you have the nurse say, well, I don't have a journal, and then their friend gets pulled in, well, I know they have a journal, they keep these things. Nurses keep these things. We keep track of these things. We know when a case has gone wrong. We want to protect ourselves just as much as physicians want to protect protect themselves. And sometimes, that works well, depending on the hospital that you work at. I work at Northern Westchester Emergency Room. Our Director of Risk Management is a lawyer. So that adds benefit that we can go to the lawyer and say, hey, you know what, I just had this error, I need some advice, what should I do, how should it be documented, what can we do to make sure that this is taken care of appropriately.
Thanks, Rick.
You're welcome.
So he touched on something that is vitally important in the practice of medical malpractice field now, is that the record, if they send it to you in paper form, is not the record. It is pretend. It is just a printout that is missing vitally important information that is required under federal and state guidelines to be contained in that record. So this all came about, and it's kind of interesting. There were two politicians very similarly situated, and they said the exact same thing when they took over as presidency, that we're going to put in electronic medical records to avoid medical mistakes, reduce costs, and improve care. But it had nothing to do with the billions of dollars being donated to them by the electronic medical records field. Nothing at all. They were focused on the patients. So when you think about focus and money and what's going to come down the line, you don't know what issue is next. For us, for the plaintiff side, it is gold. It is telling me the truth. I've been begging for the truth forever. I was looking for eraser marks, holding it up to the light. That's gone now. It's all because you just have to get a hold of some things that they shoved in the back of all these laws. If you want a detailed analysis of the laws, in the new medical malpractice book that the Law Journal published, there's a whole chapter now that goes through it. But the fact of the matter is, when they did the stimulus package, they were like, let's stimulate the economy by giving money to the hospitals and doctors so that they'll implement electronic medical records. Creatively, the reasoning behind that is because they wanted electronic health records for every person in the United States by 2014. New Jersey, because we're always ahead of the game, set up the exact same process at the same time and came up with its own rules, 2 plans. And those 2 plans said, hey, you know what? That's a good idea. We're going to have these electronic monitoring systems, and it's going to tell us who's accessing what, when, where, and why. Because they envision in 2014 that every New Jerseyan is going to have an electronic health record. So now, what's interesting about both of those is the year. It's over. It's here. So the federal government's plan has gone from incentives of paying to penalizing if not participating. So it's switched over. Now in New Jersey, it's in as well. And this is where we're at now. They've given a little stall on some of the implementations, but one of the things they can't stall is that mirroring the incentive program was HIPAA. HIPAA's never gone away. So once it went to electronic, HIPAA has put into policies and procedures that dictate how it goes. So while everyone's focusing on the incentive Medicare and Medicaid program, HIPAA has given all of these restrictions and requirements regarding the maintenance of electronic medical records and audits. So that's why it's fun. So he was talking about all these monitoring and all those alarms. They're going directly in from third-party software. We are no longer just medical malpractice attorneys. We're now product attorneys. So these things are going in automatically. In addition, you got the nurse going in. In addition, you got the doctor, you got the PA. Everybody's going into this document on a computer. And it's just functioning at a fast rate. So in a deposition we just had, he said, well, hey, there appears no vitals. Yeah? Why would that be? They didn't come over from the machine. Why? It's an IT problem. So now what do you do? You just went from a med mal case to a product case, and everybody's suing everybody in the sun because you don't know what's going on. But we all know that tech doesn't happen. No one's seen the blue screen of death. It's just never happened. But when you see these, the blame is now going around. So Ebola, right? The electronic health records what let that person out of Texas. Had nothing to do with the doctors and the nurse. Until the next day when they realized they didn't train the doctor, and the doctor wasn't checking the nurse's notes because the nurse said, do not let this person go. And the doctor's like, wait, I have to read the nurse's notes? Seriously? But how many times does that happen? Now what's great is, it's like a checklist of what everybody did. And that's the privacy and security standards. These are set, which has audit control, access reports, and policies and procedures that are mandatory for each facility to draft in regards to electronic health record. Why? Improper alteration or deletion. So, wait, they're auditing literally everything that happens on a file? Yes, the answer is yes. Permanently attached to the record of the file is every action taken on that file. Well, that's confusing. You have to be a computer nerd to know it, right? No. When they put it in and said what must be in the record, in English, I swear, it's right, we can read it and know what's going on. It tells you who accessed the record. So did the doctor look at the nurse's record? It'll say he went into this part of the chart and at what time and how long he stayed there. It'll say what he did there, such as I read the chart or entered a note. From where, which computer was he at? Was he in the patient's room? Was he down the hall? Was he on his phone? And then also when. All critical things. The only one that's not missing from the who, what, where, when is the why. And that's what the litigation is going to be because of. So if you're preparing and you're looking at these things and you're getting them in, this is, you have to pay, I think, like $15 to get a copy of it. But this is the standard that is federally implemented to oversee. If anybody needs to give me a ring, I'd be happy to give it to you. So why is this important? Because it's codified. It's codified to oversee these particular settings and audit trails. There's an audit trail of the audit trail. So if somebody's really smart and they get in and they mess up the audit trail then tells you that that other audit trail was edited. There's literally, if you look at it, a way to protect the identity and authenticity of the record. So here we go. There's a difference between an audit log and an audit trail. Very confusing. So if you're making a discovery demand or receiving a discovery demand and you don't know the difference between the two, it can be different charts. So the log is the actions by a user, whether it be multiple user, one user, but it's by user. Whereas, and it keeps the actions. And actions is literally anything that is touching that file. Creation, queries, views, additions, deletion, anything performed on the data. The audit trail are all actions on a specific record. So there is a difference. Now this became vitally important in the case where a doctor's like, did he ever look at the chart at all? Well, you'll never know if it's not on the audit trail, but where was that doctor? I can see where the doctor went. Now, yeah, obviously they're going to redact out all the other patient information, but say he's in a different room at the same time. Say something's happening and that doctor's in another location. So you can request these things and find out. The truthfulness as well, if you defend them, it could be your way out. It could actually say, yeah, it was bedside. So those are kind of neat. So in New Jersey, do we have to have it? Yeah. Audit trail, they call it node authentication, meaning where were they? They put an extra requirement on the node telling you what are you doing. So it's implemented whether you go federal or whether you go in state. So what does it look like? So first, the audit log is like any other computer program. You can put in your selections, like I want the users, I want the date, I want a filter, like any kind of filtration system. And then, this is just one of the examples of it. Look how simple it is. It's in English. The date, the time, what user was associated with it, what group, patient ID, patient name, workstation, where they were logged on, what did the audit type that's there, and what did they do. So it comes out like an Excel spreadsheet, if you ever saw one of those, like if you think back to accounting, like all the little columns, and it just scrolls down for as long as they were in there. So that's the audit log. Now you could also get audit trails which come with different names per program because they're not all in the same program. There's a million EMRs. So anyone that's seen one, it's very different when you look at it versus the printout that comes out. Because the doctor has his own screen, the nurse has their own screen. I always like to make an application go into the system, have their tech person sitting next to me, and navigate through as if I was sitting bedside. Or you can just hire a guy like him to tell me it. But it tells you under the chart view, now it's more details. It times how long they were at the bedside. I got here, entered the note, exited the note. When the time frame was in. It's so much detail just sitting there waiting for you to have it, which is vitally important to the defense and also vitally important to the plaintiff. So ask for it in electronic format because they won't give it to you unless you ask for it. But by federal statute and by state statute, if you ask for it to be produced in the electronic format, it must be turned over to you. Now the federal guidelines say 3 days to a week under the incentivism, but we know that's not going to happen. So think of it more like 35 days to get that information.
And what's important, just to add on to Jonathan's comments, you have to also think about who is documenting. And sometimes a lot of our doctors are now getting scribes because they're finding that physicians are not wanting to either dictate or they're not getting time to chart and document, so they'll have a scribe go with them and do all their typing for them, and then they just sign the note later on. And then what you'll see is I have a case that, it's an emergency room case, and you can't find when the doctor was actually at the bedside, when the doctor was providing care, because it goes from the initial assessment to the patient coding to the patient's death. So, and this is over 10 hours. So we don't know when things were occurring because this hospital used medical scribes. So make sure that you understand the scribe system as well when you're looking at this, because that can change, because you're going to need to audit those systems as well. There's so many different systems that you have to look at. So when you're preparing a case for medical malpractice, it's important to identify the objective issues within the case. You need to know both sides. Think about it. You're going to invest a lot of time and a lot of money in this case. You need to know the facts. So you need to hire someone who's going to give you an objective finding of what really happened. Do you have merit or not? Is there deviations in the standard of care? You know, one case I worked on, the hospital already knows that there was a deviation in the standard of care. They're already looking to settle, so they're working with a plaintiff attorney just to come up with a settlement so that it doesn't go to court. So it's important to know what is going on with the case. Determine the facts. Identify the scope of practice. One thing that I really want you to take away from this, and what a lot of attorneys don't realize, is that nursing is an independent profession. They do not report to physicians. They go right up their own hierarchy, from nurse to nurse manager to director of nursing to chief nursing officer to the CEO. They go linear with physicians. They work in collaboration. We do not work under a physician. Nursing has their own science that they work under, that they have their own evidence-based practice, they have their own diagnosis system. And when you're looking at deviations in nursing care, make sure that you know what their scope of practice is. Make sure you know what the established standards of care are. For emergency nursing, we have the Emergency Nurses Association that has a clear defined scope of practice. And it has a clear defined standard of care. As I said, you want to identify deviations in the standards of care pertaining to the incident, and then locate appropriate experts pertaining to the merits of the case. So if you are looking at going after an emergency room nurse, hire an emergency room nurse. But make sure that you're comparing apples to apples, not apples to oranges. Myself, I'm a master's prepared emergency room nurse who still works at the bedside. I have board certification in adult emergency room nursing. I have board certification in pediatric emergency room nursing. Getting those two components is very challenging. And also getting a master's prepared nurse still working at the bedside is also challenging. So you want to make sure that you have apples for apples, and you may have a very large challenge with this. So knowing the experts that you will need. If it's a nursing deviation in the standard of care, as I said, the nurse will have to define the scope, what is the scope of practice and what the standard of care is. A physician cannot no longer establish the standard of care for nursing. Nursing establishes their own standards of care. They have their own profession. The nurse will have appropriate credentials that will to be able to define the scope and standards of practice and care. You know, you can't hire a new grad out of college to define the standard of practice and the scope of practice and standards of care. You have to have someone who's experienced in the field. And make sure that you're not having a medical surgical nurse defining intensive care nursing, because they don't know intensive care nursing. If you had them calculate out an intensive care drip, they'd probably be like, huh? So it's important to make sure that you are comparing apples to apples. When you're looking at physicians, the same thing goes true. You have to have a physician with the same credentials. So if they're board certified in surgery, then you need a board certified surgeon. Or if you have a board certified emergency room physician, then you need a board certified emergency room physician.
As I tangled myself. So apples to apples, oranges to oranges. I mean, that's the number one thing for med-mal, is finding the correct expert and not blowing it. Because the appellate division has kicked out so many cases, it's for reasons that I disagree with, but reasons that are still things you could have noticed early on. And that's because they've made it that the statute is now dictating who can sign the affidavit of merit, but also who can expertly testify. Although it wasn't challenged yet, the legislature now has put on who can be an expert. So they've taken it out of the Supreme Court's hands on determining the expertise and have put it into the legislature in Jersey. So why is this an issue? Well, you have the affidavit of merit, and it has to be from somebody that it falls under their guidelines, those guidelines that they put in. And they are strict. You have to basically match the person that you're going after. And so if you're going after 20 people, you just cost yourself 20 affidavits of merits where they have to be credentialed correctly. So what are those credentials and how do you find it? So even though the affidavit of merit statute's here, it says point to the list, and that's the statute that's going to govern what goes on. So the first and easiest point is the physician has to be the same specialty or subspecialty at the time of the occurrence. This matters across the board, whether they are board certified or not. So even if they overlap in practice, you got a neuro that does spinal fusions, you got an ortho that does spinal fusions, not good enough. It has to be the same. Now you get confused if you continue to read down, but before you get there, these are the two approved boards of specialty boards. And this is where you can check to say, are they specialized? Because I sued a particular vein doctor who responded back, oh, I'm board certified in phlebology and your guy is not. And I sat there, I was like, there's a board certification in phlebology? So no, there's not. There's a pretend board certification of phlebology that is not approved yet. And we had to point that out, but it required another motion practice, etc. That's where they're at. That's what the statute says to go. So check here. There's all sorts of things like board certified on anti-aging, which I love seeing that one. I'm like, really? You could stop me from aging? Apparently that's a thing. So they're not sued yet. So now it changes. They've got those board certifications. What do you have to do? Easiest way to say it is if they are board certified and they've got those credentials, mirror them. Find somebody that has the exact same credentials. Even if you think you got somebody better who wrote the book on the subject, just mirror them. And here's another kicker. The year before the occurrence, not the year before testifying or the year before providing the affidavit of merit, that physician has to be actively practicing in that specialty area or teaching in it. So it's a little thing. Sometimes you'll see an expert that is not doing either at the time of the occurrence and then goes back to it later. Not good enough under the statute. Okay, so there's an or. So now you got credentialed by a hospital to treat the condition or perform the procedures as the basis of the complaint. Just because, like the spinal fusion thing, just because you are both credentialed to do it doesn't count because that first part, same specialty, still applies. So they could be technically the smarter doctor and it's thrown out. And a lot of cases have been held up in the appellate division because of that fact. So get the right one. Here's the case. Nicholas v. Minster. This will be the one that tells you all about the difference. Hopefully one day we'll get that changed because it's causing a lot of difficulties in bringing meritorious claims. So just mirror it. So here's the way to do it. You can verify the license online. State of New Jersey is awesome. We actually, under the Consumer Affairs site, tell you what are the board certifications, are they licensed, where do they go to school, all that good stuff. It's all right online, and they made it real easy, New Jersey doctor list. So if you go on that, you've got it, you find out their credentials, and you can move forward from there.
So when you're starting to get your case, you really want to start thinking through your case. It's important to ensure that you run through the entire situation, that you understand all of the facts. And this is looking at both the defense and the plaintiff side. You need to know what is going to come at you because you don't want to go to court and that's where you have to be careful with your experts that you hire. Because if you have a hired gun that they're going to say, oh yeah, I'm always going to support you, you need them to tell you, oh no, wait a second, this is not really a meritorious case, or no, that is the standard of care and they met it. You don't want to have it thrown at you in the courtroom. So make sure that you understand all of the scope of practice and the standard of care for both nursing, for whatever professions are involved with the care of that patient. So make sure that no stone is unturned. Look at that medical record inside and out. Make sure you understand the processes and the procedures that pertain to that particular incident. Think through it. And sometimes, I have lawyers who call me who will sit there and just the other day, prior to deposition, she wanted me just to run through questions. Well, how do I define the standard of care? When do I bring in an ID expert? These are the things that we're starting to look at because, we start to look at physicians who depend on other physicians to help them out. It's not one person treating a patient, it's a group of people. So and then the other thing is to make most of your demonstrative evidence. When you have a patient decompensating, a patient who has a changing condition, one of the things we start seeing is change in vital signs. Change in mentation, change in vital signs, increased heart rate. That's one of your first things that you start to see as the patient starts to decompensate. So what was on their scans? What was on their images prior to this incident? Were they in the emergency room and they accidentally misread the CAT scan and the patient actually had a ruptured spleen? Patient has a ruptured spleen or a ruptured liver. Your liver and your spleen are two very vascular organs. They will bleed out very quickly and the patient will get to the floor and they'll be coding in no time. So it's very, very important that you look at the causative agents. What's going on? What is the background for causing the alarms? You can utilize X-ray images reconstructed so that the jury can relate to them. Because think about it. If I showed you an X-ray right now, you're just going to look at it and you're like, I think I see a chest. It's not clear. You make it a bone. You highlight it. You make it colorful. You change the dynamics of it. So I'll show you just a couple examples. So this is patient lumbar spine after a fall. So we highlight it. You can make it so that it's relatable. This is the patient's actual CAT scans. So you want to get your graphic design artists on board. And sometimes you may want to do this before you go to trial. If you're working defense and you say, listen, I can animate this CT scan and say, hey, we did everything right. Or if you're on plaintiff, it's like, oh, no, 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 no. Let me show you the guns that we have. We just had a big settlement recently just because of the demonstrative evidence. We took the patient's CT scan. The patient had a ruptured diverticulum, sat in the emergency room for 10 hours, never went to surgery. What was the standard of care at that hospital? That there was a surgical consult within 1 hour of arrival. Surgery never saw that patient until hour 8. So they got cited by their state, they got cited, and then they got a massive suit from us. So it's very important to think about these things. And think about what demonstrative evidence can do. If you're going to negotiate for a settlement, having just that ace in your pocket may be something that you want. You may not pull all your cards out because we always want to make sure we hold back some of our cards. We don't show them everything. So this is a good one of a patient fall. The patient gets out of bed, the bed alarm's going off, we're trying to figure out what happened. A patient can relate to this fracture. This is a tib-fib fracture. And then you may want to, if they have a distal fracture in the upper part, we see that a lot. So you may also see a distal fibular fracture as well. But you want to make sure that it's relatable. Juries don't understand black and white, but they understand color. So it's very, very important that we make sure that they can relate to it. And these are just some more examples of wrist fractures. And we see it a lot with falls. Patients got out of bed, they fall. And what was the alarm system? And I can't stress it enough. You want to look at the alarm system. You want to look at the logs. What were the logs of the maintenance of that? Look at the training regarding that. Because if you think about a hospital system, think about the IV pumps, the beds. A bed, let me tell you, they are complex machines. Our beds in hospital systems today, they do chest PT, so they'll shake the crap out of a patient so that they can breathe. They will turn patients, they will position patients, they'll stand patients on their feet, they'll sit them in a chair. We can flip them, we can do whatever we need with beds. So to be able to do that, you need to be trained on it. So, and there's training measures that are in place. Our IV smart pumps, they're called smart pumps. But let me tell you, the biggest thing is, all of this technology is only as good as the user using it. And if they have not been properly trained, that is your first area where you want to look at.
So, demonstrative evidence is great, and he's talking about graphic design and all that fun stuff, but that costs a lot of money. But because today's films, remember that electronic health record, it also goes over for films. It's called the DICOM viewer, so they're all in electronic format. I'm a big fan of the Philips DICOM because it's free. But what it does is it allows you to take these two. So I got 2 ultrasounds here, and they just went overlaid. So you made one transparent, so you could get the measurements in. So the concept is that they missed that middle part there. But to show this can confuse people. So if you could take the 2 and walk them through, then it shows the 2 different films right next to each other. And you could then break it down with simple overlays. Be like, oh, this is how you do a nuchal fold, and put the 3 things on, and break it down, and walk with your expert. Simplistic, free, easy. Don't forget how you need to teach people. You've been with a case for 5 years. You start to know the terminology. You forget that the person that's hearing it for that 1 week, 2 week, 3 week, 4 week period hasn't heard the terms ever. So if you sit there, we've all done boards. Boards are fun. You put the boards next to each other, but they miss something. So if you put the 2 films next to each other, you're like, there's an infiltrate right here, and this turns into the lung cancer. I got it. It's interesting. But if you do that format, the PowerPoint using the DICOM, you take it, you go, all right, doctor, what are we looking at? In 2004, we had the infiltrate right here. Okay, what happened? Well, you can see where the infiltrate was, it becomes a cancerous mass, and then the patient suffers and dies. Much more powerful than the two boards next to each other. And it doesn't cost anything. It's simplistic. So the Rod v. Raritan things that if anyone goes into the demonstrative evidence and going through the electronic ones, the big deal was the blowing up, distorting and all that. It's already in the digital format from the start. So it doesn't lose the quality, and the doctors can pretty much do anything with those films in the beginning. So once they have the DICOM viewers, you ever get that disc and you put it in and it doesn't work on your computer and you get frustrated and all those? All the discs can be opened by the same program. Find one you like and then just load them all in. So you don't have to use the one it comes with. But you can put that up there, make it look pretty, be great advocates for whatever side you're on. And I know Frank and I both appreciate you listening, and I hope we taught you a few things.
Thank you.